It seems a little colder in the courtroom than it was this morning. I don't know why, but rest assured the panel had nothing to do with it. But anyway, so if you might want to just have a heated argument, that might help us a little bit. Good afternoon. We originally had 3 cases on the docket. One was continued, so we will hear the other 2 in the order in which they appear. Remember, each side has a total of 15 minutes to argue, and if there's more than one lawyer, you'll need to share that time. The appellant does have the right to reserve up to 5 minutes for rebuttal, and if you'll just let us know how much time you wish, we will program the clock accordingly. Are there any announcements or introductions? Hearing none, call the first case.
H.G. Jones, LLC versus Jordan Howell et al.
Good afternoon.
Good afternoon.
I'm Jason Farrell for the Cincinnati Insurance Company. I'd like to reserve 5 minutes if I may.
5 minutes, yes, sir.
Thank you. May it please the court, this is the appeal of the Cincinnati Insurance Company to a declaratory judgment action filed by H.G. Jones, LLC, concerning a declaration of coverage under a policy of insurance issued by Cincinnati to Jordan Howell. The trial court ruled on cross motions for summary judgment on the pleadings that the Cincinnati policy provided primary coverage to H.G. Jones. Cincinnati appeals that decision because it believes it was error to make such a ruling because an auto owner's policy issued to H.G. Jones provides primary coverage. So Jordan Howell is the named insured on the Cincinnati policy. H.G. Jones is the named insured on the auto owner's policy. Neither policy specifically names any other person or entity on the respective policies. The Cincinnati policy includes as an insured any person working as the named insured real estate manager. H.G. Jones was working as Howell's property manager, and so for the purposes of this case, qualifies as an insured under the Cincinnati policy. I would say that the auto owner's policy includes the same language in its policy. They're similar. While H.G. Jones qualifies as an insured on the Cincinnati policy, is not an additional insured, not otherwise identified in any way.
And that's where your argument and the trial court diverged. The trial court found no distinction between insured and additional insured.
That is correct, Your Honor. And so the auto owner's policy is always primary except when certain other things happen. The auto owner's policy is excess over a variety of types of insurance listed in the provision that are not the Cincinnati policy. The auto owner's policy is also excess over primary insurance available to H.G. Jones for which it has been added as an additional insured. So in order for the auto owner's policy to be excess, there has to be primary coverage somewhere else, and the insured has to have been added to the policy, not as an insured, but an additional insured.
But if there was already an insured, then if H.G. Jones was also insured, wouldn't it be additional? I mean, isn't that just a matter of semantics?
Well, our position is that additional insured is a term of art. Policies typically have a named insured. They have an insured provision for people who qualify as insureds, and sometimes they have provisions allowing others to be additional insureds.
Did this policy, Cincinnati policy, define additional insured?
It does not list that word anywhere at all.
Didn't think so.
Right.
Okay.
I believe the auto owner's policy does. It references additional insured multiple places throughout the policy.
Does it define the term additional insured?
I do not believe so. I do not believe so. I will say there is a case out of the Northern District of Georgia that says a property manager was not added as an additional insured when the property manager simply fell into the who was an insured provision of the policy. That's exactly what we have here.
In terms of a usage of this as a term of art, to be an additional insured, is it your understanding that there has to be an addition through an endorsement?
Unless it's already built into the policy where other people can be added in, but yes, you have to be added to the policy. You have to be someone who's not the named insured or someone who qualifies as an insured. You have to be someone or entity that gets added to the policy. And, typically you see this in construction context.
And added through what mechanism? And what's the is it, are we talking modified contract, or are we talking about a specific endorsement of a specific party? And what does addition look like? Assuming this is a term of art, what has to happen to make somebody an additional insured?
Typically what I see are a couple of different things. I see declarations pages that list additional insured, somewhere below insured. I also see policies that have endorsements added to them that specifically name a party as an additional insured. And I also see endorsements that add additional insureds automatically under certain circumstances. Those are the three ways that I've seen where a party can become an additional insured. As I go on, in order to have excess coverage under the auto owner's policy, there has to be primary insurance. The Cincinnati policy says it's excess over any other valid and collectible insurance, except when written specifically to cover as excess over the limits of this Cincinnati policy. The policy issued by auto owners to H.G. Jones was not written specifically to cover excess over the Cincinnati policy. It's always primary, except for certain exceptions. So we contend that the Cincinnati policy is going to be excess. And so you've got a primary policy and you've got an excess policy.
Even though your insured is the property owner and the alleged incident happened on your insured's property.
I'm just looking at the specific language in the policy to make this determination without those other extraneous facts, because I don't believe the provisions require us to look at those facts to make this decision. I think I've gone over just about everything I need to go over for that. So unless there are any other questions.
Anybody?
Okay.
Hearing none, thank you.
Thank you.
You'll have time for rebuttal.
Thank you.
Good afternoon.
Good afternoon, Your Honors. Jay Barger of the Rutherford County Bar. Council and I are here today, much as we were with the trial court last year, attempting to just interpret how these insurance policies work in a situation such as this, where you've got a homeowner and a rental management company acting as the third-party administrator for the property. I want to take just a brief step back and sort of look at what Judge Scarlett actually did. He did two things here. First, we had a round robin, the three of us did, discussing this case, and he first tried to look at who these parties are and what they were trying to achieve in these agreements and these contracts and whatnot. And then second, he did that mindful of the fact that ultimately the language of the policies is controlling, and he had to review those closely. So in the first instance, the trial court noted during oral arguments that what we have here is essentially a situation such as where there's a property manager and a homeowner, and in the record, volume 5, pages 359 and 60, Judge Scarlett acknowledges that what's going on here is that a property management company is managing dozens or hundreds of rental properties owned by various businesses or homeowners that come in as clients, and that this arrangement is somewhat analogous to an automobile policy and an umbrella insurance policy. He acknowledges that this is not an umbrella policy, but it's sort of functioning in that sort of way where you've got a property manager with policies and property managers requiring homeowners in the first instance to have coverage. So he sees that that's what's going on here, and then
But can the contract between the property management company and the landowner bind an insurer? Because it sounds like you're saying Cincinnati Insurance Company is reliable under primary coverage to provide a defense because it's insured and auto owners, the property manager agreed otherwise.
I don't believe that the private contracts between the homeowner and the property management group could bind either one of these insurance companies, but that's sort of dovetailing into my next point, which is that what obligates Cincinnati under this policy is the actual language of the policy. But when there is a little bit of ambiguity, Judge Scarlett steps back first to try to get a picture from 30,000 feet as to what's going on here and how these look. And so what he does is he doesn't rule on that basis, though. He does not. He tells us, I'm going to go back to the office, and on a Sunday I'm going to sit down and read these policies, and I'll get you guys an opinion. And he looks at the policies, and he looks at these, and he reviews this, and he says what we believe is correct. The auto owner's policy is written for a property manager and states that coverage is available to you, but does not provide primary coverage when there is other insurance available to which you've been added as an additional insured. In this case, we contend that the property manager has been added as an additional insured. Cincinnati admits that we're an insured under their policy. The Cincy policy specifically states on page 190 of the record that it covers anyone acting as your property manager. Council just even acknowledged that here. And their policy does not in any way make any distinction between somebody who is an insured and someone who is an, quote, additional insured. I've cited Tennessee case law that says that an insured and an additional insured have the same rights unless limited by the policy. And your honors were questioning that earlier.
Is the provision drawing a distinction, though, just in terms of definition of excess? I mean, it lists as an additional insured rather than an insured. So, I mean, it's drawing some distinction there.
Which one is drawing a distinction?
In terms of the AO policy, right?
Yeah.
The AO policy said, it could have just said, if you were insured but under another policy, then it's excess.
Right, and it does say additional insured, but the terms are not capitalized and the terms are not defined. It doesn't say that they have to be a named insured or named as an insured. It says added as an additional insured is what the language says. I'm sure you guys know that.
Additional insured is used multiple times, and I believe opposing counsel says more than 20 times in this document that additional insured is used. Why shouldn't we understand this as a term that has a meaning? And it's certainly utilized a significant number of times in the insurance provision.
And auto owners is treating, they didn't define the term and it's not capitalized. I think because of that, I think that you're using those terms in the ordinary sense that you would use that term, which is just meaning that they've been added as an insured on the policy, which is what they were on the Cincinnati policy.
Does that mean we're reading the word additional out here? I mean, we're just deleting the word additional?
No, I think your honors were getting to this when you were questioning the opposing counsel here. Cincinnati, Judge Clement, you asked, is this a matter of semantics? And I think, yes, it is, because Cincinnati could have made a distinction. Cincinnati could put in their policy that we have one class of rights and responsibilities and for primary and named insureds. We've got another one for somebody who's named as an additional insured, and they've done that. And you've asked that, and they had no riders, no addendums, nothing on this.
Why isn't our concern with what AO failed to put in its policy? I mean, if we've got something that in the insurance industry is often understood as a term of art, and it's clear that at least in some settings this is regarded as a term of art within the insurance industry, why wasn't the obligation on AO to define, if it's going to utilize additional insured, to make clear that it's not referring to it in the manner that it's often understood in the insurance industry?
I think they try to do that by stating that the auto owner's policy is secondary if their insured is added. I don't know that the auto owners would ever try to restrict their access, their occasions in which they're secondary insurance. But if they try to, would the auto owner's policy ever try to restrict occasions in which its coverage is secondary? I don't think that it would. I don't think that it's going to try to create a special category which limits its ability to be secondary in situations such as this, because they are, I mean, if they're insuring a property manager, they may be on the hook for literally thousands of pieces of property, and so they are wanting to be secondary in all those instances. And I think that's sort of what Judge Scarlett saw at the, like I said, at the 30,000 foot level. But the policy that Cincinnati had, the Cincinnati policy does not make those distinctions either. They could have said that if you are an additional insured and your name's not on the policy, then you are always and in all circumstances secondary. But they didn't. It said that it would not be secondary if there is against policies that are specifically written for that written to cover as excess over the limits of the insurance policies that apply here. And in this case, the auto owner's policy was specifically written to cover as excess over these limits.
Conventionally, if we're looking at an insurance policy, there's a ambiguity in the language and it would be construed against the drafter here. This seems more complex in that we have two insurance companies, two insurance policies, and the construction and how exactly are we supposed to engage in that sort of lean of reading and interpretation in that setting?
And I think that's exactly what, I mean, you're almost verbatim saying exactly what Judge Scarlett was saying when we were having this conversation with him. And he took the policies, he sat down, he looked at them, he looked at the overall structure of how this is set up in the real world and what they've done, and ultimately looked at the language of the policies themselves. And he said, that they both had escape clauses, but that it's designed in Cincinnati. He essentially accepted my arguments.
Or the excess clauses? I mean, is there a difference between those two things? I mean, isn't an escape clause a provision that would leave no liability?
I say escape clause. I'm really meant excess.
Okay.
Yeah, and there's no real escape clause, but it's each one of these is trying to say that they are excess over the other one, essentially. But the court ultimately ruled in our favor because they believed that that Cincinnati could have made a distinction on this if they had wanted to make a distinction between this, and they acknowledge that we are a named insured under the policy. We're named insured, but they're trying to make a distinction, Cincinnati is, and trying to get you to read language into their policy that does not exist, that there is a special section or a standard for additional insureds that's unique and distinct from that of insured, and there's not. And because of that, and because of the way their policy is written.
Am I correct that under the Cincinnati policy, the landlord, Mr. Howell, is the named insured, but that the Jones Property Management Company is not named anywhere?
That's my understanding.
And it comes in under which clause or which?
It comes in under what are
terminology?
Pages 190 and 201 of the record. Page 190 and 201 of the record, where the insured means any organization while acting as your real estate agent. That's on page 190 of the record. And I think that's probably cited in both of our briefs.
And it says insured means, that's a definition.
Yes, Your Honor. It's each of the following is also considered an insured, any person or organization while acting as your real estate manager. And so they've stipulated to that. They've acknowledged that the property manager is an insured under the policy. But they're asking you to read language into their policy that there's a distinction between an insured and an additional insured that simply just doesn't exist. And that's why Judge Scarlett ultimately believed.
And for the property manager to be an additional insured, the argument is there has to be an endorsement or another provision that says, and H.G. Jones is hereby classified as an additional insured. Is that the argument?
That's my argument, Your Honor. There's nowhere in the Cincy policy that says, in addition to the category of insureds, we have a second category of people who have coverage. We call them additional insureds. Here's what rights they have. Here's how you meet that definition. None of that is in their policy. None of that whatsoever. But they're trying to, and they tried to argue in front of Judge Scarlett that you all should read that into the policy. And that because the auto owner's policy says that you should be added as an additional insured, that there's some sort of distinction there that even their own policy does not make. And that's ultimately why Judge Scarlett, we believe, ruled the way he did, and found that the Cincinnati policy was the primary policy in this situation, and we would ask that you would affirm the trial court's ruling. Do you have any other questions?
I'm hearing none. Thank you.
Thank you.
Mr. Barker. Mr. Farrell, your rebuttal.
Thank you. You don't need to read anything into the Cincinnati policy. Cincinnati is not the one with the issue, the potential ambiguity issue. It's the auto owner's policy. Auto owners is the one that has the issue about whether additional insured means something other than insured. That's not the Cincinnati policy. The Cincinnati policy doesn't even contemplate additional insureds because it's not necessary to do so in order to establish what is covered under its policy. The policy that H.G. Jones has is the type of policy that affords coverage under certain situations to additional insureds. Had H.G. Jones required Mr. Howell to get that type of policy, they could have obtained the relief they're seeking in this lawsuit from Howell's carrier, whether it be Cincinnati or someone else. So I think that you've got to look at this additional insured as a term of art, as you mentioned a moment ago. Other states have done so. The industry refers to it as additional insured. The contract mentioned by Mr. Barger a while ago, I believe, requires adding an additional insured. So additional insured is a word that's contemplated to have a different meaning than insured.
Is there an affidavit or other evidence in the record that states this is a defined term in the industry or a term of art in the industry?
I don't believe so, Your Honor. I don't think I have as some out-of-state cases that reference that.
There's arguments to that effect,
Sure.
but there's no evidence of a professional with the Insurance Service Organization, ISO, which writes all these policies.
We have nothing like that, Your Honor, in this case. So we believe that it's clear that you got to look at the auto owner's policy to figure out what the auto owner's policy does. And you don't look at the Cincinnati policy to figure out what the auto owner's policy does. They're two different policies, but you do have to construe them together, and then they fit together. In this case, they're not repugnant. They fit perfectly. The auto owner's policy is always primary except when it's not. The Cincinnati policy is always excess except when it's not.
Can the court find that each or both of them are primarily responsible for coverage?
I believe that would not be the correct determination, because there's one that does provide primary coverage under its other insurance provision, and the Cincinnati policy doesn't provide it unless there is an exception for it. They're sort of opposite, the way I see it. So I believe that's all that I have, Your Honor. We would request that the ruling be overturned and that a determination be made that Cincinnati provides excess coverage. Yes.
So make sure they are not an additional party because there was no addition through endorsement? Is that right? Not right?
Under the Cincinnati policy, H.G. Jones is not an additional insured because there's nothing in that policy that mentions.
Under the AO policy.
I'm sorry.
Under the AO policy, that the excess provision language in the AO policy that says for which you have been added as an additional insured.
And you have to be added to the policy.
You have to be added, and you have to be added. Your view of that is that the AO policy is adopting it as a term of art that requires addition through endorsement. Is that, am I understanding this correctly?
That's right. There's two things. You have to be an additional insured, whatever that means, and then added to the policy. H.G. Jones was not added to the policy in any way. They just qualified as insured under the who's an insured language.
You have to be both an additional insured and added?
That's what the language says, Your Honor. It says, for which you have been added as an additional insured.
Okay, well, I'm not sure that's two things, but okay. All right.
Okay. Well, thank you all very much.
Well, we'll give some additional thought to this narrow issue and take the matter under advisement. Thank you.
Thank you so much.
Call the next case, please.
Brandon Todd Negrin versus Andrew Nicholas Roach.